Okay, so we have live online, Mr. Attistern. You're there?
Yes, I am.
Okay, fine. So you're live on Iriefm. Let me welcome you first of all to this program, Easy Skanking, and thanks for taking up our offer.
My pleasure.
Okay, before we get into the details of the recent appeal from Buju Banton, and before we get into your subsequent press statement, could you please remind our listeners as to what it is that Buju is actually appealing? What is before the appellate court?
All right. So, as I'm sure you and your listeners know, Mr. Banton was tried twice for these offenses, federal offenses in Florida. The first time it resulted in a mistrial because the jury could not agree, a majority of the jurors believing that he was innocent. And then he was tried a second time, and he was convicted that time, and he was sentenced, and he's now doing his sentence in federal prison. After he was sentenced and went to prison, it came out from a newspaper interview that the foreperson of the jury had done outside research, both into the law and also into Mr. Irie and his music, and had reported on what she had found to the other jurors during the deliberations. As a result, Mr. Irie's attorneys applied to the court for a new trial, and a series of hearings were held and resulted in an order granting him a new trial on one of the three charges upon which he was convicted, but denying the new trial on the other two, on the theory that what the foreperson of the jury had researched only applied to the one charge and not to the others, a point in which we quite strongly disagree with. And at that point, Professor Ogletree and myself came into the case, and we took an appeal to the Court of Appeals. What has happened is that the appeal was prepared, was argued, and the court, on its own, raised the question as to whether it had jurisdiction to consider it, because there is a doctrine in United States federal appellate law which says you can only appeal what's called a final judgment. And they said, they asked the question as to whether the fact that one of the cases was open and pending for a new trial, whether that makes this a not final judgment. And ironically, both us and the government agreed that it was certainly final as to, and appealable as to, the two indictments upon which Mr. Irie, Buju Banton, was convicted and sentenced, and he had an absolute right to appeal it. Nevertheless, the court said, the court said, we agree with you. However, there was a prior decision by a different set of three judges some years ago which came to the opposite conclusion, and under the rules of this circuit court, the first decision takes precedence, and until and unless we can set aside that by the full court, which has 11 judges on it, they felt that they could not exercise any jurisdiction.
Okay. Hold a minute there.
That's where we are.
That's where we are. Okay. In your press statement, you said it is not correct that Buju has lost his appeal. What is in fact correct? I know you gave us a bit a while ago, but explain to us in very simple terms what is in fact correct, and what did the appellate court... So, yes, go ahead.
All right, so basically what the court said, first of all, there's no question that Buju Banton has an absolute right to appeal the decision which denied him a new trial for the juror misconduct. This was outrageous misconduct by the juror. and it clearly prejudiced the jury against him and gives him a right to appeal this. Nobody disagrees with the idea that he should have a right to appeal it, but it has not been decided. The court did not decide his appeal. Instead, what they said is, well, that this is the wrong time, or that under the prior decision of another judge, another set of judges of the court, this is the wrong time. You have to wait until the other charge is disposed of, and then we can have jurisdiction of the case. So they never decided his appeal. His appeal simply remains out there, and we think we have a right to have it decided now, because if you wait until the government gets around to doing something with the other charge, we can wait forever.
Right.
In fact, and he could serve his entire sentence.
Right.
In fact, the government said they're not really interested in the other charge. The government, all they care is that they've got him convicted and he's doing time. So we're going to press forward and say, one way or the other, he needs to have his right to an appeal, and he needs to have a decision on his claim that his rights were violated and that he was denied a fair and impartial jury and a fair deliberation by the jury on the evidence, and only on the evidence that was presented at the trial. Okay.
So the three-panel judge makes this ruling, right? Yes. And they are requesting that if the full court hear this ruling. Is this something that is a suggestion, or is it a right?
We have the right to petition the entire court. The court can decide on its own whether it will hear it's called a petition for in bank consideration, a petition for the entire court to hear the case. The court has the right to decide, to take it up as a full court or not. So we will depend upon the discretion of the full court as to whether it will take up our appeal at this time. However, under the standards of the court, one of the standard reasons for the court considering matters as a full or in-bank court is when there are inconsistent decisions by different panels, and that's precisely what we have here. We have one panel of judges that said, in this situation, there is no jurisdiction, and two other panels that came afterwards that said, we don't agree, but we have to follow that, which is really kind of, frustrating.
Is it a technicality? Is it a technicality in the courts? I mean, that's what I'm not quite.
It's a complete technicality. It's an erroneous technicality. It is not one that is required by any of the rules, but it is nothing but a technicality which stands in the way of the appeal that he has an absolute right to present.
Okay. How confident are you as an appellate lawyer of Buju's that this technicality can be removed and can be removed in short order?
I can't. I think I am optimistic that it can be removed and will be removed, because I think it is so completely wrong. As I told you before, which is really kind of remarkable, on this particular point, the government does not even disagree with us. Mm-hmm. The government agrees with us that the court has jurisdiction to hear the appeal. So I feel optimistic that the court will do something. How long it will take, I can't tell you. It's not, as you know, unfortunately, the wheels of justice sometimes grind very slowly.
Very slowly, for real.
And they have done so in this case.
Okay, let us say this technicality, for argument's sake, I'm going to ask you both ways. Let us say it is not removed. Where do the lawyers go from here? Well,
there are two things we could do. We can apply to the United States Supreme Court. That's one possibility. The other possibility is we then go back to the the trial court, the district court in Tampa, and we insist that the government drop the pending charge when the government has stated that if we don't win the appeal, if they would not pursue the outstanding charge, so we will then insist that they either try it or they drop it. My guess is that they would drop it, and that we would then refile the appeal. And at that point, everybody agrees that we would have a right to pursue the appeal. The unfortunate part is it would mean more and more months of delay and more months of Buju Banton serving a sentence that he should not be serving.
Right. Okay. Let us say the technicality is removed. How much closer will you be to an actual hearing, or is that out of your power? The time. The timing is completely out of my power. If the court says we're going to send it back to the three judges that heard the case before, because they have considered the appeal, they have heard the argument, and they could then the full court could tell the three judges, now it's time for you to decide it. Right. Okay. Those are the two routes it could take. Okay. All right. Let us say, how confident are you now that, having removed the technicality, Buju Banton's verdict will be overturned and he will get a new trial and ultimately be set free? How confident are you of that?
I can only say this is one of the strongest appeals that I have seen in my practice.
Really?
We first of all, we have undeniable misconduct by a juror. Nobody denies that the juror committed misconduct. It is also undeniable that the juror that it not only influenced her, but she also shared her research, her illegal research, with other members of the jury. Under the law, that means, once we've shown that means the government has the burden of showing that it did not prejudice Mr. Banton at all. And we don't see any way that the government has shown that it didn't prejudice him. It certainly did prejudice him. And I don't see any way that they could ever show that. She did research, first of all, on conspiracy law. She told the jurors what she found about conspiracy law. She told them about a case which deals with the issue of when someone can be convicted under a conspiracy of an offense where he didn't participate in the offense. Well, here we have a case where at the end of the day, when the drug transaction actually took place, Mr. Banton was nowhere to be seen. He had nothing to do with it. So there's every likelihood that this research played a part in the jury's decision to convict him. Secondly, she also researched on the web all about Buju Banton and his music. Well, there's no way to know what she found. There's no way to know what she told other people. And so the government cannot possibly carry its burden of showing that this did not hurt the defendant and did not result in the conviction.
Because they don't have the information at all. They don't know who knows what.
They don't have it, and you can't even ask for it. You know, it's even forbidden to ask to go into and ask the jury, how did you think about this? What was your opinion of this? So I think this is once the court gets to it, the court will have to rule in our client's favor.
Okay, Mr. Stern, just help me here now with the facts. So the media is reporting that Buju lost his appeal. However, the Court of Appeal stated that they didn't have jurisdiction to decide the case. It's not a case. It's not a case that he lost. It's just that they
That's right. That's right. They did not decide the appeal itself. as I said before, everyone agrees that he has a right to have this appeal, decided. It's only a question of when.
Right.
And they just said, well, not now, because there's something still open in the court below.
Okay.
And we think that's wrong.
Okay. And on blank case, tell me, explain to us in layman terms as best as possible what that is.
Which I missed that.
When a hearing is called an en banc hearing.
En banc.
Yes.
En banc it means the whole bench. And the court has 11 members altogether.
Right.
The 11th Circuit Court of Appeals. But they ordinarily, only rarely sit all together. They divide into panels of 3 judges at a time.
Mm-hmm.
And 99% of all cases are decided by 3-judge panels.
Right.
And it's only when a question of exceptional importance comes up, or a question of inconsistent results by different panels of the court, that they say, all right, we're going to hear this all together and we're going to straighten this out.
Right.
We're going to speak for the entire court.
Right.
And so we are requesting consideration by the entire court to straighten out what is obviously an inconsistent ruling or inconsistent theory that are being articulated by the various panels.
Okay, another fact that our listeners need to know is that the appellate lawyers, which you are one, are now requesting that the full court make an order to remove the technicality and give the 3-court panel jurisdiction over the case.
Right.
And when
Or decide it themselves.
Right. And when this technicality is removed, then the next step is, as you explained, an en blanc hearing, right?
Well, no, we're asking for the en banc hearing for them to decide that there is jurisdiction to hear the case.
Okay, right.
Once that's decided, then the case will be considered either by that entire court or by the 3-judge panel.
Oh, okay, got you. And you're saying to us that you have every reason to believe that the final court will overturn the verdict, and that sometime, hopefully very soon, set the DJ free?
They should do so because he's entitled to it.
Well, a lot of legal jargon, but thank you so very much, Mr. Stern, because that's sometimes what our listeners just don't understand, and I'm very happy that you took the time out with me this afternoon to really help us through the jargon, and I'm really hoping that the press and our listeners will understand more. As soon as we have more information, can I ask of you, even if you don't do an interview live, but to give us some information to pass on to our listeners?
I'll be happy to do that.
Thank you so very much. And once again, thanks for taking time out of your schedule to talk with us.
Well, thank you.
Take care.
Bye.
Wonderful. So that's Mr. Atty Stern, and he is one of the appellate lawyers for Buju Banton, the other co-counsel attorney being Mr. Charles Ogletree, who he referred to. And thank you very much for that. So the information that the media provided us with is incorrect. The media is reporting that Buju lost his appeal. However, as we follow the appellate lawyer's conversation a while ago, the Court of Appeal stated that they didn't have jurisdiction to decide the case regarding Mark Myrie. So what they're doing is suggesting that the 3-panel judge or the 3-panel judges suggesting that the full court of 11 judges confirm its jurisdiction so it can decide on the case one way or the other. And having gotten rid of the technicality, the request will be made that the full court make such an order that, the appellate lawyers are doing this now, making an appeal that the full court make, the request is now being made that the full court make such an order, remove the technicality, and have that 3-panel judge, as he said, or the full court try this case. So we're going to find out more. We're going to try and remove some of the legal terms, or certainly explain some of the legal terms. I know Mr. Stern certainly did that for me. I certainly hope he did that for you.